Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 153C proceedings. As all we know that section 153C proceedings or the assessment under section 153C can be done in relation to a person on which the search is not made but whose documents are found in the search of any other person and that search have taken place on any other assessee before 1st April 2021. The basic condition for making the assessment under section 153C is reference to the incriminating material found in the search of the another assessee. The question before the tribunal was that where the assessing officer and the CIT appeal has both referred to the incriminating material in their orders, but they have not mentioned that what incriminating material was there, or if there is a total absence of any satisfaction note, so whether in that case the addition made in the income of the assessee on any ground is justified. This issue has been taken up by Honorable Chandigarh ITAT B bench in the case of Rawalpindi Cooperative Cinema Society Limited versus Deputy Commissioner of Income Tax, and this case is related to the assessment year 18-19. In the present case, the assessee belongs to K group. There was a search on K group, and on the basis of that search a notice was issued to the assessee under section 153C for the assessment year 18-19. For the assessment year 18-19, the assessee has sold a land, and on that land the assessee has showed long-term capital loss. For calculating this loss, the assessee has taken the cost of the land which was there in 2001 and accordingly must have done some indexation and has shown the long-term capital loss. But the assessing officer, for calculating the income of the assessee, took the cost of the land which was appearing in the balance sheet for the assessment year 17-18 and accordingly calculated long-term capital gain in spite of long-term capital loss. When this matter was before the CIT appeal, the CIT appeal gave some partial relief to the assessee based on some valuation as per circle rate. So there were cross appeals in the income tax tribunal both by income tax department and the assessee. When this matter was heard by tribunal, the tribunal prima facie was of the opinion that there is a prerequisite to make reference to the incriminating material found relating to the assessee. So the tribunal to confirm that whether there is incriminating material with the assessing officer or not, the bench directed the assessing officer to file copy of the satisfaction note as recorded by the assessing officer. But very surprisingly, the revenue was not able to produce the copy of the satisfaction note before the tribunal. The tribunal said that in the absence of satisfaction note, it cannot be said that there is some incriminating material which has been gathered by the revenue in the search of K. So when there is no satisfaction note, so what to talk about the incriminating material? The tribunal said that the satisfaction note is not available, and in the lower proceedings, that is at the assessment level and at the CIT appeal level, both the officers have referred to the incriminating material, but they have grossly failed to mention that what incriminating material was there. So in the absence of satisfaction note or the incriminating material relating to the addition made in the case of the assessee, the addition should not sustain. Friends, it has been seen that whenever there is search on any assessee, then the assessment of the various assessees are made in a very loosely and manner without recording any satisfaction, without recording any reasons. So these type of cases really help the assessee where the principles of natural justice and the procedure of law are kept under the carpet to make the additions. At the end of this video, once again I am repeating the name of the case. The name of the case is Rawalpindi Cooperative Cinema Society Limited versus Deputy Commissioner of Income Tax, and this case is reported in 125 ITR Tribunal at page number 185, and the date of the judgment is 15th January 2025. Thank you, friends.